Hello. Sarah and I thought we would give you an update since we last spoke about the comings and goings in the commercial landlord and tenant world. It's been a bit busy over the last week or so, and we thought it was probably a good idea to let you know what's going on if you're not already up to speed. So there are a couple of things that we wanted just to let you know about, of four in total, looking at what's happening with forfeiture, looking at what's happening with CRA and insolvency and the new code of practice that the government has introduced as at 24th of June. Sarah is just going to update us in relation to forfeiture and insolvency, and I will do a bit of rambling on about CRA and the code of practice. So to mix it up a bit, let's introduce Sarah and forfeiture.
Thank you for that introduction, Charlotte.
You're welcome.
Most people will know that as a result of the Coronavirus Act, which was passed shortly after lockdown, there was a restriction on landlords' right to forfeit commercial premises for non-payment of rent. That was initially until the 30th of June. So that would have just taken us past the June quarter day for rent payments. That was extended shortly before that date, and the prohibition now extends through to the 30th of September. So we've passed the June quarter day, the September quarter day will pass, and then the restriction should be lifted on the 30th of September, although it can be extended further beyond that date. Whether or not it will be, I think, will depend very much upon how things go over the next weeks and months with the lifting of the restrictions and the country coming out of lockdown. So at the moment, the restrictions on forfeiting for non-payment of rent continue, so that currently isn't an option available to landlords. But to assist parties in trying to sort out rent issues, there has been a code of conduct brought when I say into force. It doesn't have any legal weight. It's a code of practice. It's for landlords and tenants to discuss the situation in respect of their leases and rent payments. And I think Charlotte can tell us a little bit about how that will work.
This is something that was introduced on the 24th of June, and the government would like everybody to pay attention to it. Their stated objective, which sounds great, is to provide the right support to those in the chain of commercial property payments so that the economy can recover swiftly. All marvellous. What it sets out is basically, in the shorthand, is everybody needs to play nicely and together. There needs to be transparency, there needs to be honesty and trust in the relationship, which is possibly anticipating that is the way everybody will operate. And as we have certainly seen for lots of our clients, people are not operating in that way. There are those who are more likely than not able to pay the rent but choosing not to take advantage of the moratorium on forfeiture and CRA, which I'll update you on in a second. And there are those who are really struggling, so generally the tenants, where landlords are not making any concessions. So the code of practice, whilst it's endorsed by all of the relevant commercial property bodies, it has no teeth. So it's not, as Sarah said, it's not something that's statute that's capable of being enforced. It's not something that is a pre-action protocol, which is something that the court would be looking at prior to any proceedings being instituted. It's basically exactly what it says, a code of practice, where landlords and tenants are expected to be as honest with each other as possible. UK Finance has introduced some guidelines which are helpful. Back in May, there was £27.5 billion worth of lending that was on offer to businesses, and I think at that stage, I think it's about the 6th of May, about 650,000 businesses had taken advantage of that. And lenders are being flexible with the support that they're offering, such as amendments to facilities and capital payment holidays, much in the same way as consumers and their mortgage holidays. It's along the same lines. If a landlord is discussing those type of concessions with lenders, then those are expected to be passed down to the tenants. I think, as I said at the outset, what is ideal is transparency, collaboration between the parties with a good, healthy dose of honesty so that the parties can trust each other. It's a terrible situation that we're in. In an ideal world, everybody's interests would be aligned, but I'm not sure in the reality that everybody's interests are aligned. So anyway, the idea is that everybody complies with this code of practice. It's found on the government website, fully downloadable. It provides information about the level of detail that individuals and businesses are supposed to provide to each other. And that's about it really on the code of practice. One of the things that was already amended was the commercial rent arrears recovery procedure. From 7 days, it was extended to 90 days worth of rent being outstanding. And as from the June quarter date, that now needs to be 189 days outstanding. This is the second amendment to the Taking Control of Goods and Certification of Enforcement Agents Amendment number 2, Coronavirus Regulations 2020, a snappy little title if ever there was one. So these are to mirror the restrictions or protections, depending on which side of the fence you're on, in relation to forfeiture that Sarah has talked about. And the intention, it is stated, is to provide businesses with additional protection and flexibility in managing their finances. Sarah, would you mind wrapping us up with a bit of insolvency update?
Absolutely. So landlords who are faced with tenants who aren't paying and who a landlord thinks should be paying or could be paying really don't have that many options. It might be tempting to look at insolvency and possibly to serve a statutory demand on your tenant in order to encourage payment. But the law has also had something to say about that, and the Corporate Insolvency and Governance Act has very recently been passed, and that imposes restrictions on the insolvency process. So far as companies are concerned, there is now a restriction on presentation of a winding up petition based on a statutory demand that's been served between the period of the 1st of March to the 30th of September this year. So any statutory demand served in that period can't be relied upon for the basis of an insolvency application. If you have grounds to issue a winding up petition on another basis, so for example, an inability of the creditor to pay debts, then that also is prohibited unless you've got reasonable grounds for believing that coronavirus had no effect on the finances of your tenant in a landlord and tenant situation, or that the company would have had debt issues regardless of coronavirus. I suspect that those are going to be quite high hurdles to cross, and the courts have additional powers to make orders in respect of petitions presented between the 27th of April and the coming into force of the Act, so that they can make an order to restore the position of a company to the position it would have been in had a petition not been issued. So the insolvency process as a means of recovering debt or rent is now prohibited, as well as forfeiture and cross. So that avenue is no longer available. Of course, there's absolutely no restriction on serving a statutory demand, but it will now mean nothing because you won't be able to serve any petition based upon it.
It's all a bit tricky, isn't it?
It is.
The landscape for property generally.
I think the intention is that if parties follow the code of conduct, then hopefully they won't have need to have recourse to the other enforcement options that are available. But that depends upon the openness of the parties and the willingness and ability of them to negotiate and come to an agreement, I suppose.
Yeah, everybody's got competing interests, really, haven't they?
Yes.
I hope that in the fullness of time, hopefully in the next couple of months, we will be here giving you all sorts of positive news about what you can and can't do with your property portfolios. But in the meantime, I feel like two doomsday sayers, whatever the right description is, harbingers of doom, that's it. Um, I hope this has been useful for you. If you have any queries, then please just drop us a line or give us a call. We'd be very happy to talk to you. And in the meantime, I hope everything is going well at your end. Take care, everybody.
Bye.